I'm Jen Shaw. We spend our days helping employers sort through messy workplace situations, often in real time and often with a lot on the line. On this podcast, we'll walk through those issues, what's coming up, what actually matters, where employers get into trouble, and what to do next. No theory, just practical guidance you can use. Welcome to another episode of the Shaw Law Group Workplace Wake Up Podcast, where we discuss the California employment law issues employers face every day, and more importantly, how to stay ahead of them. I'm Jen Shaw. Whether your organization has worked with unions for decades or is navigating labor relations for the first time, the same mistakes continue to create unnecessary legal risk. New labor relations professionals haven't yet learned the fundamentals, and experienced professionals sometimes stop paying attention to them because they've become routine. Today, I'm joined by my colleague, Shaw Law Group attorney Dilpreet Mayall, to discuss the labor relations principles every employer should understand, and why getting the basics right is often the key to avoiding grievances, unfair labor practice charges, and unnecessary conflict. So, Dilpreet, thank you so much for joining me today. I'm so happy to have you.
Thank you so much, Jen. It is an absolute pleasure to be a part of this.
Oh, I love this podcast, and I love it when we get to have guests and visitors. And here's the thing, Dilpreet. We are not a labor firm, but we are really lucky to have you because you have done labor relations work and you're interested in building our practice in that area. So I'm so happy to have you on the podcast where you can sort of tell us a little bit about what labor relations is all about and why even employers that don't have unions need to think about labor relations, right? So let's start with the basics. There's a federal law that dictates all of this, right, Dilpreet?
Right, absolutely.
And that's the National Labor Relations Act.
Exactly. So here's what the National Labor Relations Act actually does protect. And here's why, like you already mentioned, employers without a union should even care about it. I mean, the key concept here is protected concerted activity. That means when two or more employees acting together about wages, hours, or working conditions. And here's the part that sometimes surprises people. It applies whether or not there is a union involved.
I don't get that. Well, I mean, I guess I get that, but I think some of our listeners may not get that. What does that mean? Because the law is called the National Labor Relations Act. It was passed in the early 1930s to give employees the right to unionize. It certainly contains a lot of rules about how to adopt a union, how to get a union to represent you, how to get rid of a union. There's all kinds of stuff in there.
Absolutely.
Some of the people who listen to us have a union, and some of the people who listen to us don't. Why should everybody be interested in this topic?
Well, here's the thing. I mean, maybe it could come down to an example for, if that helps even. But really comes down to any kind of concerted activity is protected activity, whether or not there's a union involved. So let's say if you have like 3 employees and they come into a manager's office together and they complain about the schedule. Well, that's a protected activity, and that's actually covered under the National Labor Relations Act. It doesn't matter whether the workplace has already seen a union or if anyone even said the word union, the protections already exist.
So, Dilpreet, I get it. Protected concerted activity is not necessarily about a union. But why do employers even need to care about this concept of protected activity?
Absolutely. Great question. I mean, the response that an employer takes can create an unfair labor practice charge, whether or not there is a union involved. So the practical takeaway is simple, that when employees raise a concern as a group, slow down. That situation has some legal protection around it and needs to be handled with more care than a routine one-on-one conversation or just an ordinary complaint.
Okay, interesting. So under the National Labor Relations Act, there could be what we call a ULP, right? An unfair labor practice charge.
Yes.
But also it could just be retaliation, right? Like if I'm saying, Dilpreet, it's not fair, you're paying Paul more than me, and I think it's because of my sex. And you say, oh, Jen, glad you brought that up. By the way, we're doing a reduction in force and you're being eliminated. Right. I could make the argument, hey, I engaged in protected activity by saying all the women in this organization need to be paid fairly. And you fired me, which is retaliation because I engaged in protected activity. that is prohibited not only by the National Labor Relations Act, but also by state law here in California and various other states, right?
Exactly.
Okay.
Exactly. If you've engaged in a protected activity and as the employer is taking an adverse action, that is completely something that would be considered as retaliation, both as in California law as well as under the National Labor Relations Act.
Okay. But it's not necessarily retaliation, right? I mean, what if I complain about how women are being paid in our company, but you have me on video stealing $100 from somebody's purse on the third floor, and you decide you're going to fire me because I've done that? Am I Teflon coated? Am I protected from being terminated because I engaged in this protected concerted activity?
Excellent question, Jen. Excellent question. And now we're getting into a very sticky situation where you have two things happening at once and they're concurrent. And as an employer, we should still know that, yes, these rights, the employees' rights exist. At the same time, your managerial rights did not just completely diminish. Right? So if somebody is engaging in both protected activity as well as unprotected, such as any kind of theft, well, we should look at both. And that's where the documentation always becomes key. And this is always going to be, your biggest form of defense here.
Okay, so it's not that I'm precluded from taking action against someone. It's that I better be able to show I didn't do it because of their protected activity. And this is what labor relations professionals who work in union workplaces, this is what they're dealing with, right? They're dealing with this idea of, all right, why did the manager take the action the manager took, or the supervisor, or the lead, or the foreman, or whoever it is? Was it related to protected concerted activity, or was there a legitimate business reason for what we did, correct?
Exactly. Yeah.
Okay.
You've nailed it there.
Okay, where do new labor relations professionals get into trouble on that issue of discipline and corrective action?
Well, disciplining is always interesting. And where people tend to get tripped up is on disciplining on how something was said instead of dealing on what was said. So here's a typical scenario where a group raises a shared concern and one employee gets heated, maybe raises their voice, or maybe says says something that the manager finds disrespectful, right? And then the write-up that follows says words like disruptive or unprofessional. And that write-up, ultimately, because that's the paper trail that's being created, is the problem later on. When conduct happens in the middle of protected activity, such as that complaint itself, that group complaint, it gets evaluated a little bit differently than your ordinary conduct. So some heat, some frustration, then whatever comes with the territory, when you're disciplining the tone, you may actually be disciplining the protected activity itself.
Okay, so when you say that somebody is disruptive or unprofessional, it could also be perceived to be disruptive and unprofessional to advocate for a union. So when you discipline or take corrective action against someone for that kind of behavior, you're really getting very close to the protected activity rather than saying, yes, it was unprofessional of me to steal $100 from somebody's purse. But what you're really going to say is we have Jen on video stealing $100 from somebody's purse. It has nothing to do with protected activity.
Exactly. You want to keep the two separate completely to avoid an unfair labor, practice charge. That's what we want
avoid
to
a
do.
ULP, to avoid other legal claims, but also to just avoid disruption at work, right? I mean, look, employee happiness is important. We need to have a good morale, a good environment in the workplace. So when you have people who feel like they're being attacked or they're being punished because they've engaged in protected activity, that doesn't generate a culture of collaboration and professionalism.
Exactly. It's one thing to say you truly do not want a disruptive environment, and it's another to say, hey, we actually just want to have people shy away from speaking up whatsoever. All right? I mean, those are two separate concepts here, where we want to be able to maintain the protected activity, but also, like you mentioned, there's another intangible to this of just having a great morale and collaborative environment.
Okay, so let's make clear to everybody on the podcast, only union environments have labor relations specialists or advisors, right? I mean, these are employees who are hired in an organization because they're supposed to be working with a union. So, like here in Sacramento, all of the state agencies, public entities, cities, counties, water districts, they're all going to have a labor relations professional on staff because they're going to be facilitating conversations and negotiations and things between the employer and the union. Is that correct?
I mean, it is correct in the sense that, yes, that typically the ones who have the labor relations professionals. It doesn't mean that only the ones with the unions need to have labor relations professionals. I think that they're helpful even for non-union employers.
Yes, but we call them something different, right? Don't we just call them HR?
HR. Yeah, exactly.
Okay.
HR specialists, yeah.
So this is the sort of language that I want everybody to be familiar with, okay? If you're in a union environment, it is very likely you're going to have an employee, a job title, a classification that is focused on labor relations. If you're a private sector entity that does not have a union, you're not going to have a labor relations person by title, but a significant role of your HR team or your leadership team is to do the same thing that a labor relations professional would do in terms of encouraging people to speak up about issues they're concerned about, making sure we're following up when somebody raises a complaint, making sure we're addressing issues that employees are raising. So from that perspective, this idea of labor relations applies to every workplace, right?
It does. It does. Whether it's considered as an HR specialist or it's under the actual labor relations profession with somebody with the union involved, you're ultimately going to have someone that covers the ground for both.
Okay, now let's just assume that we're dealing with a workplace where they have a union, because many of our listeners are actually a part of organizations that have unions. So let me ask you a couple questions. First of all, what is a CBA? What is a contract?
Sure. So the contract itself is a collective bargaining agreement, and that is where the union and the employer will negotiate on a cycle, maybe every 3 to 5 years, it could range, and in which case they discuss the working conditions, and that's where people tend to get tripped up.
Okay, so the collective bargaining agreement or the contract is the agreement between the employer and the union about certain terms and conditions, right?
Exactly. Yeah.
Okay. Now, if an organization has a CBA, do they also need an employee handbook?
Yeah, and that's where the employers can get tripped up a bit, right? So of course you're going to have your own handbook that covers everything else that the CBA does not. The CBA is going to cover a bunch of work conditions, maybe classifications, and a bunch of other provisions, and then your handbook is really going to get into everything else, from all your managerial rights, because one thing that the CBA doesn't cover are those managerial rights. Now, one thing you want to make sure though is they're negotiated or rewritten at different times, right? Your CBA is negotiated every cycle of 3 to 5 years. It depends on the CBA. Whereas your handbook might get updated annually or on a specific schedule. So over time, they start to contradict each other, or they can at least, where it's like discipline procedures, scheduling, leave, and any one of those contradictions is a potential future grievance. And overall, later on, it actually hurts your credibility because when the union finds the conflict, which they eventually will in your handbook, the employer looks like it doesn't know its own rules.
Okay, so if you work in a union environment, you're going to have to follow the CBA, which are the negotiated terms and conditions of employment. And then
Exactly.
everything else that wasn't negotiated is going to be in a policy manual or an employee handbook or some other document. And you have to make sure that you're following both.
Exactly. I mean, the employer handbook is the way for you to supplement everything that wasn't discussed, or negotiated for, but still things that you would like to have as an employer for your staff.
So
Right?
you're
So that
saying
you're
the
able to
employee
follow.
handbook is that document
Exactly.
where you can cover additional things. Okay. Now, one of the things we hear a lot about is this adversarial relationship between a union and an employer, and I've worked for a union employer before, and I know that it's much different than working without a union because you have more of a direct relationship with the employer. But talk to me for a couple minutes about, is it just a foregone conclusion that the employer and the union have to have this sort of negative adversarial relationship?
I wish that wasn't the case in which people jump to that conclusion here, because what ends up happening is when you see the relationship and you default to this adversarial relationship, those employers end up negotiating every single interaction, right? Everything becomes a fight from there because there's no trust to draw upon. The alternative, on the other hand, is to treat the relationship like a working relationship, right? Something that you can do hand in hand. And what that might look like in practice is maybe before you're going to be changing maybe some working conditions, some scheduling, or you're just making anything drastic, you let the union know in advance. And it's not saying something where, oh, I'm actually going to give up my managerial rights, or I'm going to abandon this, or I'm trying to avoid hard conversations. It's actually just having a more collaborative environment to begin with, and you actually tend to build trust like that. And now everything that gets resolved tends to be informal as opposed to, oh yeah, I just got hit with the grievance, and I didn't catch this on my Friday evening, right? So this is just something that you can still hold your position as an employer and with your managerial rights, but also keep them in the loop. It doesn't have to be so confrontational every single time.
Okay, so a couple of terms here that I want to make sure everybody understands. Managerial rights are the employer's rights, correct?
The employer's rights, exactly.
Okay.
Yeah.
And then when you talk about the employee filing a grievance, that's like an internal complaint. But a grievance is something that is filed when you have a union environment and the employee is saying, look, you didn't follow the collective bargaining agreement, right? Or the contract.
Right. Typically, the employee may go to their union representative and say like, hey, look, I just want to double check on this. It looks like this is happening. They have some form of complaint. The union itself then and depending on the relationship, and this is where it becomes critical, right? So if you already have an informal trust, they may directly just reach out to the employer and be like, hey, look, what's going on over here? And that can get resolved much easier. Now, if it doesn't, that's when a grievance will get filed and there's a formal complaint drafted. And if it doesn't get resolved, it ultimately leads to an arbitration or whatever else negotiated in the CBA.
And by whatever else, you mean whatever process or procedure is
exactly.
in place.
Yeah.
Okay. So
which typically will look like an arbitration procedure.
Will look like a formal hearing type of process.
Exactly.
Okay. So the bottom line is, for folks who are listening to us who do have unions, the labor relations job is very important because that position, that individual in that role, or individuals in that role, they're going to be the ones who try to help maintain a relatively positive relationship with the union, make sure the employees get what they're supposed to be getting, make sure the employer is doing what it's allowed to do, and that you have a relatively collaborative environment so that productivity isn't negatively affected, right? I mean, doesn't it come down to that at the end?
It does come down to your professionals. I also think there's even one more layer to this, if you don't mind me chiming in on this. I think what ends up happening is your frontline leaders are the ones that create the record, right? The ones who are your supervisors, the ones who are essentially your leaders of your company, who your employees and staff actually see, right? So like all your write-ups, the emails, the responses to the complaints, it gets written by whoever was closest to the moment, which ends up being your supervisors. And legally, the leader's conduct is the employer's conduct in a sense, right? So any kind of statement they make is almost on behalf of the employer. So this is where the gap occurs. And most organizations, they train their leaders on compliance maybe once a year, or don't prepare them for specific moments, or maybe on their walls they have listed as all the principles that they want to hammer home, but it really doesn't get hammered in practice or in weekly meetings. That's where I feel like the best employers have your frontline leaders trained in a way where that gap of exposure gets covered. Right? You're not just getting an annual compliance training. You're actually hitting on the points weekly or monthly. And so they're actually trained to handle those decisions in a heated situation. And also on when the decisions touch the CBA or the contracts.
Okay. So obviously critical issues here that we've talked about. And I think, one of the sort of messages I hear you conveying is that successful labor relations isn't really about winning every disagreement, right? It's about consistently applying sound principles, communicating effectively, and building credibility with your employees before problems arise, right?
Exactly.
Okay. And employers that experience the fewest labor disputes are often the ones that never lose sight of these fundamentals.
Never lose sight of the fundamentals. You make sure you keep your CBA and your handbooks intact so they're not contradicting one another. You maintain your relationships with the union, right? It's very easy for this to become a transactional relationship over time. And keep training your leaders, right? Keep consistent training on your leaders. And everything else, as far as documentation goes, you may side with this on this, Jen, I think mundane and boring and routine is the best defense all the time, right? If
this is just how we always do it.
This is how we do this, right?
Yeah.
This conduct occurred. Oh yeah, it's an input-output. We document this way. And if you can, always claim that, well, you've created a nice defense for yourself as an employer.
So Dilpreet, you have given us such good information here today. And obviously, those of our listeners who have unionized workforces really need to think about these ideas. And if you don't want to have a union in your work environment and you want to be able to have direct communications with your employees, you have to treat them right. One of the things that I think is always so interesting is when you look at statistics about why employees unionize, it's rarely about the money. It's about respect. It's about feeling like they have a seat at the table. Dilpreet,
Right.
Thank you so much for joining me here today. I really appreciate it.
I appreciate your time, Jen. I appreciate you letting me be a part of this. As an avid listener, I'm just honored to be a part of this.
Oh, thank you so much. Everyone, thank you for joining us here today. Go out and do something nice for someone, and we'll see you next time. Shaw Law Group, we solve workplace problems. Real-world guidance for real workplace decisions. The Workplace Wake Up podcast is produced for general educational and informational purposes only. The views expressed are those of the speakers and do not constitute legal advice or create an attorney-client relationship. The law is complex and constantly changing. Therefore, you should contact an employment lawyer in your jurisdiction for advice regarding your specific situation.